Hello, everyone. Thanks for joining us for our Maryland Realtors Professional Standards Training video series. The series consists of a number of short videos explaining various parts of the professional standards process. This video is a mock hearing before a panel from the local association's Professional Standards Committee. Let me give you a quick overview of the facts and the parties who will appear today during the ethics hearing. We have before us Rebecca Realtor, the listing broker. In her efforts to sell a furnished apartment building, Rebecca used advertising describing the property, including such phrases as modern updates, most units have new appliances, and excellent earnings record. We also have before us Elizabeth Buyer. Elizabeth saw the ad and called Rebecca. Elizabeth was shown 3 nicely appointed units on the property, signed an offer to buy, and wrote a check for a deposit. A few days later, she made a more careful inspection of the property and its earnings statements and filed a complaint against Rebecca with the Association of Realtors, charging misleading and exaggerated advertising. Elizabeth's complaint was referred to the Grievance Committee, which, after its review and evaluation, referred it to the Professional Standards Administrator for a hearing to be scheduled before a hearing panel of the Professional Standards Committee. I will now step aside and we will begin the mock hearing.
Okay, everyone, as you know, I will be serving as chair of the Professional Standards hearing panel today. As a preliminary matter, we need to make sure that everyone who is supposed to be present is present, and we also need to make sure that everyone is seated in the appropriate places. So first, please ask all parties, including witnesses, to come into the hearing room.
We're ready for you.
Ladies and gentlemen, I now call this hearing to order. The Professional Standards Committee is charged with holding appropriate hearings for the Extraordinary Association of Realtors in accordance with the procedures as set forth in the association's bylaws in matters concerning unethical conduct of an association member or members, or in the arbitration of a business dispute arising out of the real estate business as defined in the bylaws of the association. The body meeting here is an impartial panel of Professional Standards Committee members who have been selected and called today to ascertain the truth in the particular matter at hand, which is an ethics proceeding, and to render a decision on the testimony and evidence presented. The Professional Standards Committee is a body duly constituted under the authority of the Extraordinary Association of Realtors and has been duly appointed by the association president and approved by the board of directors. You may want to look at Part 6 of your Code of Ethics and Arbitration Manual, Form E-16, which shows the suggested seating arrangements for a hearing. At this time, I would like to introduce the members of this panel. My name is Robert Kemp. I'll be serving as chairperson of this panel. To my left is Kathleen D'Artez, and to my right is Jeff Bernstein. They are both members of the Professional Standards Committee and are serving as members of this hearing panel. Present at this hearing to my left is Elizabeth Buyer, the complainant. As I understand it, you do not have an attorney present or any witnesses to testify on your behalf. Is that correct?
That is correct.
If the complainant or respondent are represented by counsel and or accompanied by witnesses, confirm that the other was notified in advance. If not, ask if there is an objection. If none, have the necessary party sign a statement to that effect.
Also present at this hearing to my right is Rebecca Realtor, the respondent. You have also waived your right to an attorney and have no witnesses to testify on your behalf. Is that correct?
Correct.
Let the record show that both parties have waived the right to an attorney and that there are no witnesses to testify as today's proceeding. Also present at this hearing is Elise Bean, the Professional Standards Administrator for the Extraordinary Association of Realtors. This hearing is being mechanically recorded. The parties are specifically advised that any recording or transcription that may be made of this proceeding can only be used for purposes of appeal, and any other use, including use in other ethics or arbitration hearings, is expressly prohibited.
If an attorney representing the association is present, they should be introduced at this time.
I would also like to point out that the association has also waived its right to have an attorney present on our behalf. This hearing has been established to consider the complaint of Elizabeth Beyer against Rebecca Realtor, alleging violation of Article 12 of the Code of Ethics of the National Association of Realtors. The complaint filed by the complainant is as follows. The respondent has been charged with violating Article 12 of the Code of Ethics. Article 12 reads as follows. Realtors shall be honest and truthful in their real estate communications, and shall present a true picture in their advertising, marketing, and other representations. Realtors shall ensure that their status as real estate professionals is readily apparent in their advertising, marketing, and other representations, and that the recipients of all real estate communications are or have been notified that those communications are from a real estate professional. This panel is not dealing with questions of law, and it is not governed by technical rules of evidence which may apply in courts. This panel will seek to determine all ascertainable and relevant facts pertaining to the matter under consideration, to arrive at a peer judgment and decision by the panel that is fair to all of the parties. The panel is governed and directed by the bylaws of the Extraordinary Association of Realtors and the Code of Ethics of the National Association of Realtors. The panel determines its own rules of evidence and its own procedures to be followed with the objectives of equity and due process. The following has been generally accepted and ruled on by this panel as to the procedures to be followed during this hearing.
There are a number of procedures set forth in Part 5 of the Code of Ethics and Arbitration Manual. There is a section called Chairperson's Procedural Guide, Conduct of an Ethics Hearing, which sets forth a thorough explanation of the procedures. The chairperson should determine if any of the parties prefer affirmation in lieu of being sworn. After being sworn or affirmed, the chairperson should excuse any witnesses and ask them to wait outside until called, and ask the remaining parties to be seated. We're going to continue with our mock hearing with the chair swearing in the witnesses.
At this time, I request that both persons present in the room who expect to testify at this hearing stand and be sworn, or make the appropriate affirmation in lieu of being sworn. Please raise your right hand, and following the question I will pose, answer in the affirmative if you do so swear. Do you swear that the statements you're about to make at this hearing are the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Let the record show that all parties have answered in the affirmative. You may be seated. Both the complainant and the respondent were mailed a copy of the outline of a procedure for an ethics hearing. Did each of you receive the outline?
Yes. Yes.
Let the record show that the complainant and the respondent have both stated that they did receive the outline.
If either party answers no, they should be given a copy of the outline, and the chairperson should determine whether that party has any objections to proceeding.
Do you have any questions concerning that outline of procedure?
No. Yes, I have a question. The outline says, recording the hearing, the board shall have a court reporter present at the hearing or shall record the proceeding. Any party may, at the board's discretion, record the proceeding or utilize a court reporter at their own expense. If a party utilizes a court reporter and orders a transcript, a copy of the transcription shall be made at the party's expense and presented to the Professional Standards Administrator. I don't want to pay for a court reporter because my money is tight after overpaying for this building. But I wanted to know if I could use the voice recorder on my own phone to record the proceedings.
As the outline says, it is within the discretion of the board or association to determine whether they will permit a party to record the proceedings. I would like to make you aware of one of the statements of professional standards policy applicable to ethics proceedings, specifically policy number 55. The policy states, cellular phones, two-way radios, and other transmitting devices may not be operated during ethics hearings, arbitration hearings, appeal hearings, and procedural review hearings absent specific advance authorization from the panel chair. As chair, and consistent with policy number 55, I am denying your request to record the proceeding using your cell phone. Each party shall be given an opportunity for an opening statement, which shall briefly outline the basic premise of the party's position. You will have an opportunity to present your entire case at a later time during this hearing. First, we will hear from Elizabeth, the complainant.
Good morning, everyone. My opening statement is very simple. Rebecca lied to me. First, she lied to me in the advertisement, and then she lied to my face. I wanted to purchase an investment property, and I had saved and sacrificed for a long time to be able to do that. I saw Rebecca's advertisement for a furnished apartment, which was right in the price range and in the right area for me. So I called right away to see the apartment building. She showed me 3 units, which were in great condition. They had been updated and were nicely appointed. I didn't have a lot of time, so I prepared an offer and sent it over. I wanted to take advantage of this opportunity. Rebecca never told me that these were the only units that had been updated, or the rest of the units were in terrible condition. But that wasn't her only lie. I asked her about the earning records for the building, and she told me that it was excellent. Her word, excellent. After my offer had been accepted, I was able to look more closely at the building and the financials and realized that Rebecca had lied or exaggerated about a lot of things. If I had known the true condition of the apartment and the financials, I would not have submitted an offer on this property. Long story short, her advertising was misleading at best and full of exaggerations and flat-out lies at worst.
Thank you, Elizabeth. We will now hear from Rebecca, the respondent.
First, I want to thank the chair and the members of the panel for serving today. I appreciate the opportunity to explain my side of the story. First, what Elizabeth just said is not what she said in her complaint. In the complaint, she only mentions the advertisement. She didn't say anything about lying to her face. I know why she didn't say that in her complaint. Because it never happened. I never lied to her face, and the statements in the advertisement, in my opinion, did not depart from accepted standards in advertising. The building was about 10 years old, so I felt free to say that all of its units were modern. The ad also stated most units have new appliances, which again is true because of the fact that the building was about 10 years old. Finally, in my opinion, the earnings record of the building for its entire operating life was accurately described as excellent. Since it had shown a loss in only 2 of its 10 years, I think what happened here is that Elizabeth got cold feet and just changed her mind. I'm sorry, but that's not how it works. If she got cold feet, she should bear the consequences of that, not me.
Thank you, Rebecca. The complainant will now state her case and present any evidence that she may have.
For several months, I have been looking for an investment property in this general location and in this price range. I only have very limited time available on the day Rebecca showed me the property. The 3 apartments which she showed me were in excellent condition, so I thought it was advisable to make an offer. I felt that I could place full reliance on Rebecca's representation of the property, both in what she told me verbally and in her advertising. When I went back for a second, more thorough inspection, I saw that the 3 apartments Rebecca showed me were the only apartments in the building that were updated. The other 9 units were badly in need of renovation. Moreover, the earnings record of the building, which was satisfactory for the 2 years immediately preceding, had shown high vacancy rates and a loss in 2 of the 10 years of the building's life. The building had shown a definitely low return in 3 years and had never shown earnings record that could be described as excellent.
Thank you, Elizabeth. Do you have any evidence you would like to submit that might support your complaint?
Yes, I do. In addition to my testimony, I would like to give the panel copies of some photos which show that Rebecca lied about the property condition. I have copies of the photo on my tablet, so let me get that.
Wait, didn't the chair say you couldn't use your phone or any? What was that? Transmitting device? I don't think she should be allowed to use her tablet. Isn't that a transmitting device, Mr. Chair?
Since Rebecca has objected, let me ask you, Elizabeth, do you have hard copies of the photos that could be submitted as evidence instead?
I do, but I think that's ridiculous. Anyways, here are my photos. I have 4 of them.
Rebecca, Do you object to these?
No.
I'm marking these as Complainant Exhibit 1. You may continue.
The first photo is the one that was advertised and the one of the units that I was shown. Nice, renovated with new appliances. That's what I thought I was buying because that's what she made me believe I was buying. But look at the other 3 photos. These units are disgusting. They haven't been renovated, they need to be painted, and the appliances look like they've been there since the 1980s. There's no way this is ethical conduct for a realtor.
Thank you, Elizabeth. Rebecca, would you like to cross-examine the complainant?
No, that's not necessary.
Let the record show that the respondent has chosen not to cross-examine. The respondent will now state her case and present any evidence that she may have.
I would like to point out that the complaint does not say that I made any verbal misrepresentations or false statements. So that makes this a narrower proceeding. The complaint is only based on the written advertising. I strongly disagree with how the buyer categorizes my advertising. The advertising does not depart from accepted standards in advertising, because the building was 10 years old, not built in the 1980s, or whatever it was that she said. I felt free to say that all of the units were modern. When I said that most units have new appliances, that too was based on the fact that the building was about 10 years old. The last point involves the earnings record of the building. It was and still is my opinion that the earnings record of the building for its entire operating life can reasonably be described as excellent, since it had shown a loss in only 2 of its 10 years. I have nothing further to add.
Thank you, Rebecca. Elizabeth, would you like to cross-examine the respondent?
No, thank you.
Let the record show that the complainant has chosen not to cross-examine. I will now open the floor to the panel to ask any questions.
I have a question. Rebecca, how many apartment units did you show to Elizabeth?
I showed her 3 apartments, and she didn't ask to see any more.
How many of the apartment units have been renovated?
3.
Were those the 3 units that you showed to Elizabeth?
Yes.
And in how many units had the original appliances been replaced?
3.
Were those the 3 units that you showed to Elizabeth?
Yes, but there's nothing wrong with that. Naturally, in showing the building, I directed attention to the most attractive features. This is just ordinary competence in selling. If I didn't do that, the seller would file a complaint against me.
At this time, both the complainant and the respondent will be given an opportunity to make a summary or closing statement if they so desire. The complainant's closing statement will be heard first.
If there are no more questions from the panel, we will proceed to closing statements. We will hear first from the complainant, Elizabeth.
I don't think I need to say too much because it's very clear that Rebecca lied, made misrepresentations, concealed the truth, whatever you want to call it. She didn't advertise or describe the property accurately. Just use simple math. There were 12 units and 9 of them had not been renovated. So 75% had not been renovated and 25% had. The same with the earning record for the building. It had shown high vacancy rates and a loss of 2 of the 10 years of the building's life. The building had shown a definitely low return in 3 years, and it had never shown earnings records that could be described as excellent. The panel cannot allow her to get away with this. That concludes my statement.
Thank you, Elizabeth. We will now hear the closing statements from Rebecca, the respondent.
Thank you. The reality of the situation is that the property is a 12-unit building in a neighborhood that is undergoing gentrification. This building is 10 years old, which I would say is considered modern anywhere, but especially in this neighborhood. Elizabeth knew that the units had been rented and normal wear and tear was to be expected. As for the earnings record, the real estate market was terrible 10 years ago and has only recently recovered. During those 10 years, this building had only shown a loss in 2 years. During the worst real estate market in recent memory, this building was profitable for 8 out of 10 years. This is simply a great building in a great neighborhood. Maybe she didn't run her numbers properly, or maybe she needs to buy a few more cans of paint. But that shows a lack of due diligence on the buyer's part, not an ethical lapse on my part. That concludes my statement.
Thank you, Rebecca. Do each of you feel that this hearing has been conducted fairly?
Yes.
Yes.
Let the record show that both the complainant and the respondent have indicated that they feel that this hearing has been conducted fairly. Have each of you had an adequate opportunity to testify, present evidence and witnesses, and conduct cross-examination?
Yes.
Yes.
Let the record show that both the complainant and the respondent have indicated that they have had an adequate opportunity to testify, present evidence and witnesses, and conduct cross-examination.
If any party answers no, ask them to state any concern, and if there's any merit to the concern, take steps to remedy any possible deficiency.
Before we adjourn the hearing of this panel, all persons present are advised that the report and findings of this panel are considered confidential. It will be available only to members of this panel, to the parties, to counsel and staff as required, and to the Board of Directors of the Extraordinary Association of Realtors, as directed by provisions of Part 4, Sections 22 and 23 of the manual, or as otherwise specified in the manual. Upon final action by the directors, the findings or conclusions of this panel shall be disseminated to the parties by the President of the Association, as directed by Part 4, Section 23 of the manual. Parties will be notified of the decision within the required time after this hearing is adjourned. You are also reminded that any recording or transcription of this proceeding can only be used for purposes of appeal, and that all other uses, including use in other ethics or arbitration hearings, is expressly prohibited. There being no further business to be considered in this hearing, this portion of the hearing stands adjourned.
After adjournment, the panel will remain in executive session and prepare a finding of fact to set forth the decision. The panel will follow explicitly the procedures set forth in the Code of Ethics and Arbitration Manual regarding appeals. Associations should have association counsel review ethics decisions prior to any action of the panel becoming final.
It is the conclusion of the hearing panel that the respondent's advertising used exaggeration and had not presented a true picture in her representations to the buyer. Rebecca Realtor is found in violation of Article 12.
The hearing panel's decision is considered final when it is in writing, signed by members of the panel following their personal review, and after review by board counsel if required. The final decision of the panel will be filed with the Professional Standards Administrator the day of the hearing, or no later than 48 hours following the hearing. The Professional Standards Administrator shall transmit a copy of the decision to the complainant and respondent within 5 days of receipt of the final decision. A reasonable delay, such as any delay in obtaining board counsel's review, doesn't invalidate the association's procedures nor the decision. That concludes our mock ethics hearing training video. Thanks for watching. And as always, if you have any questions, feel free to contact the legal department at Maryland Realtors.